around the country, and things were beginning to kind of bubble up in our practice, where people were asking all these new questions that we hadn't really gotten before from our filmmakers, like, what do I do with my footage if I'm arrested while I'm shooting something? How do I tell a story about a public figure who is part of this current administration who might be very upset about the story I'm telling? And do I have the same protections that I might have had only 2 years ago, or at least thought I had only 2 years ago? How do I tell a story about someone who politically might be complicated, and I want to make sure I can tell that story fairly, while at the same time not being Leni Riefenstahl and creating a hagiography of someone who might not be the filmmaker's personal taste to like this person, but thinks it's an important topic to talk about. How do we deal with all of this when it also expands to the regular protester? If we want to use archival footage being shot by regular people, if we are a protester and we are out there trying to tell a story for our own purposes, not necessarily to license something to a Netflix or an HBO, how do we deal with the concepts of incitement? And if we are telling a story that we think is incredibly important, but that the voice within that story is arguably a hate speech, or is going to potentially be seen as being, just by the way it will be interpreted by this moment of the hegemonic forces of our culture, to be seen as amplifying someone's point of view, that might be scary. How does all of this intersect with both the ethics of journalism and the ethics of documentary filmmaking, and all of the legal challenges to get to that place? How do we get access if we want to tell the story of the press, and we need to get access, like our client Liz Garbus made a 4-part series about the New York Times covering the first year of Donald Trump. How do you get access to the New York Times and continue to tell that story while at the same time protecting the New York Times' the sources that were coming out of the quote-unquote leaky White House? How do you do those things while making sure your project can be financed, can be insured, and can be distributed in a traditional commerce way? So these are all these issues that used to be, we would often talk about art and commerce, and now we're really at a point where we're talking about the actual intersection of protest and the First Amendment, and worrying about when the First Amendment is no longer protected potentially by the state, but it's what you need to do to be in critique of the state. So we're here today to talk about a bunch of different things. I think we can start with Andrew, who's going to talk a bit about just kind of making sure we understand the baselines of what the First Amendment is, and how to guide you in thinking about the basics before you start thinking about how you would make this kind of movie.
So I'm happy to be here. My name is Andrew Ungberg. So as Victoria mentioned, I want to just do a quick overview of what are the rights that we enjoy as documentary filmmakers, but also what are the other people's rights that we need to be aware of when making a documentary or covering a protest. So obviously, as it says on the side of the tin, the First Amendment, it protects us against government censorship, and also whether that's by the federal authorities or the state. There's limited protections for certain public-private entities, public universities, but it does not protect against private censorship. So this is the line between the situation with Jim Acosta and being banned on Twitter. One is squarely under the First Amendment, and the other is unfortunately still a private matter between a private customer and a service provider. So we can debate about whether platforms have obligations to comport themselves in a way that's more responsible and maybe not so, waiving their status as a private corporation, but for the time being banned on Twitter, being banned on Facebook, any of these big platforms a lot of us rely on, it's still private content. It's not censorship in the way the First Amendment is concerned about. But even if we're talking about government actors, we're talking about the New York City Police at a parade or a protest, there's still content-neutral regulations that can be put into place, so they can cordon the press off into a pen somewhere and ask that you stand there and cover from that vantage point. again, that's a little problematic. It seems that journalists in the pen have less rights than a citizen with a smartphone. But the courts have repeatedly upheld the right of the government to set time, place, and manner restrictions that are so-called content neutral. I mean, one of the big issues now is whether, in fact, such restrictions are content neutral. Are they just going around in the guise of being content neutral, but we're putting everybody in a press pen 3 blocks away from where the actual action is happening, and basically smothering the ability of journalists and documentary filmmakers to cover events. And then also we're putting people in a pen and then using them as a political football at rallies. You know, we're putting everybody in one spot, and is that truly content neutral? Also built into the First Amendment is the right to film law enforcement, which for our purposes is very, very important. That is an evolving right. I think that everybody in this room would likely agree that we ought to have the ability to film the police. It helps with transparency. It helps, it protects the officers. It protects the people who they're dealing with. And as long as we're doing it responsibly from a space away that allows the officers to do their job, it ought to be allowed. And thankfully, I'd say about 60% of the federal appellate courts in the country have recognized some version of the right to film law enforcement under the First Amendment. But it's not ubiquitous, and it's good to know before you go. So a lot of the larger law enforcement organizations, the New York Police, New York PD, LAPD, they now have publicly available policies about your rights to film officers on the job, and it's important to know. And it's not long; it's 2 pages. It's the sort of thing that it behooves everyone to look at before you're out and interacting with law enforcement. And then finally, separate from the government's rights and our rights against the government, we have the rights of other people. So there's the right of publicity, the right of people to control the use of their image in commercial situations. That's less of a concern for documentary filmmakers because generally your First Amendment rights to create and expressive work trump somebody else's rights to control whether or not they want to be in it. But as Julie will discuss later, the right of publicity can still spook your distributors or your network, and so it's important to wrap up those rights. You have to avoid false light or defamation, either saying untrue things about people or portraying them in ways that lead people to think untrue things about them. And then revelation of private facts. There's documentary film, and then there's the Hulk Hogan case where it's private facts that ended up with a $150 million plus judgment. So knowing where the line is between public activity, political opinion, things that the public has a genuine interest in knowing, and purely private activity that might be interesting to know about but doesn't really serve any sort of public purpose. And that can come into effect, if you have people who are running around on the far reaches of the internet in one corner or another. Are those public people in the context of the debate that they're encouraging in the communities where they're having it? Or are they private individuals sitting at home and wherever and just posting onto the internet? So the divide between whether people are public officials and private officials impacts their rights, how much you can film them. I mean, the general guideline is things that are happening in public should be able to be filmed and can be filmed. So that's public protests, speeches at public events. If it's out on the street in front of City Hall, it's very easy. If it's in someone's basement and there's only 5 people who've been invited, it's probably private, but you get into tricky situations like this. Can anyone come in here and come and see us? Are we in a purely private space right now? Is this a public space? There are spaces that it's less clear. So,
well, they did make us sign a release.
Yes, we did sign a release on the way in. So that's just a quick kind of survey of all the different rights that are in the mix. And they kind of are the background against which the rest of all of this happens.
And just to put a somewhat of a more complicated spin on that, Andrew and I are currently working on a project which has a huge international reach with a big public figure. And part of it is that a lot of what we're telling you, or most of what we're telling you, all of what we're telling you, is really rooted in the United States legal jurisprudence. We've recently discovered that, for example, in Italy, it doesn't matter what your release might say, there is actually a constitutional protection for people who are deemed to be somewhat private, and that's how that's defined under Italian law is a whole other question, to not have to be in a movie or in a photo that they don't want to be in. And so it's really important if you are doing this, not only to know your local laws in terms of the rules of engagement with the cops, with the rules of engagement with protesters in general. The other thing to be really conscious of is that to the extent any of it is international and you hope to have worldwide distribution, you have to make sure that you have, whoever is your counsel has separate counsel and local counsel who can actually guide you on those laws in that territory. And we've unfortunately come across lots of filmmakers who are like, our lawyer said it was okay, and then they're in a problem, and we're like, well, this isn't governed by this law. So just, you have to be extra careful about that.
Could I just add one thing?
Yeah.
So the Europeans' new massive privacy law, the GDPR, it comes up, people think about it when they're in the context of social media or being online or businesses storing data, but it's very, very broad. And there are lawyers who have interpreted the personal information definition under that law to include political opinion. And so if that's correct, if you film somebody voicing a political opinion, you've captured personal information, and now you could be held to all of these kind of onerous standards under the European GDPR, one of which is the right of the person who gave the information to review it, correct it as they define correction, and delete it. And so one of the things that's been a challenge is, a lot of our clients are used to getting the release and then they're good to go. Once you sign the release, there's no going back. But the truth is more complicated now for almost the entirety of continental Europe.
So something else is sometimes more, that's where the law intersects with other law, and sometimes you are not as protected as you might have thought. But some other things sometimes happen where the law might protect you, or it should, but you still have challenges of whether you can use it, because at the end of the day, you have a financier and a distributor and an errors and omissions policy. So it's really, can you help us understand why that can be frustrating sometimes?
Sure. So a lot of what we do day to day is we work with the buyers. They have these extensive legal and business affairs teams, and when our clients are producing documentaries and series for them, we want to make sure that we're adhering to the standards and the parameters that are set out by those networks. So, it doesn't always go hand in hand with what your First Amendment rights are. They want to make sure that you have releases. And so it's boring, and I'll share a small anecdote that's somewhat unrelated, but I took my kids to go voting with me. And I took them into the polling place. They saw me fill in the little bubbles and scan it in. And afterwards I said, guys, what do you think? That was really cool. We just, participated in some civil engagement. And they said, Mommy, that was boring. And so a lot of what I do is the boring stuff. But I said it's boring, but it's also really important. And sometimes the most important things are boring. So I'm going to talk about the boring stuff, but also it's very important. So Andrew touched upon the release forms. We always recommend that our producers go out with their release forms fully buttoned up and they have all the rights. I think the basic rights are you want to make sure that you can exploit your project worldwide in perpetuity in all media. You want to have advertising and promotional rights because you need a way to advertise your film, which has something to do with the rights of publicity that Andrew was talking about. And then another really important piece of paper that we work on is called an access agreement. And we'll do these with governmental agencies, Department of Homeland Security, ICE, what else? The DEA, a lot of times with different police departments, if we're following them around, sometimes we do ride-alongs with them. We want to make sure that we have all that paperwork buttoned up. So, basically what those forms look like, if you're familiar with the releases that you need to go out with, you have your appearance releases for the individuals who you're interviewing, but in addition to that, you have to have your location agreements and your materials releases so that you have licensed third-party materials. The location agreements are very similar to these access agreements, basically a location agreement on steroids. You have all of these rights and also all of these restrictions. And so part of our job is trying to narrow the restrictions. And a lot of that, we have to understand that these, especially, governmental agencies, they have a lot of competing interests to protect, and we need to respect that. They're trying to protect the security of their agents. They're trying to protect sometimes very confidential and secure information. And so what we'll do is negotiate within their forms a certain level of review rights. So they'll have the ability to review the certain segments within your documentary or your series, and we try to narrow what they're able to request changes on. So we'll narrow it to changes based on factual accuracy, based on whether they determine it impedes an ongoing investigation, whether they may find that there's an undercover agent who is identifiable within the footage, and sometimes even the way that they are depicted, which maybe that's not necessarily ideal, but if you want their cooperation, it's something we typically will encourage you to live with.
One thing, just to put a kind of a real life spin on that, is that we have a client who's making a documentary. We have many clients making many different documentaries that have to do with the refugee and immigration issues that have come to the fore in the last 2 years. But one of the clients has been working on this before 2016, and we negotiated an agreement with the Department of Homeland Security and ICE, which felt like that language in the location agreement, access agreement, we're going to be okay because it's a government entity, and as Andrew said before, they have the most strict scrutiny about how they can limit your speech and what you can record about, what you can say about them, what you can depict about them. And so that kind of language where they have some oversight or review rights, you felt previously that would be used in a very limited way because they don't want to risk that they will fall victim easily to a First Amendment claim against them, or in some places slap and different things. But we don't know how that's going to work out today. So there is a certain sense of, we'll see if things can be pretextually used against people. We don't know yet how that's going to play out. But the one thing that is good is that while there are some buyers that are extremely not open to there not being releases and not being certain kinds of things, they have gotten used to the government entity, police force, type of hospital releases where there's approvals. Because a lot of the regular buyers of series are often like health, there's like a million different series about going in for surgery and a million different series about cops and all that stuff. So a lot of those buyers have gotten very used to the risk of that. Yet other types of risks, they're very unopen to. So you have to really know, it's not just like look at your delivery schedule and know what the releases are. You kind of have to know like who the BA is and those buyers. How open are they? What is their background in the First Amendment? How likely are they to be open to a real conversation, both about the law and about the reality of risk? And that takes kind of a long relationship with a lot of these places, but that's hard when some of these buyers are brand new. And the very, very new buyers don't actually know their risk appetite yet. They're not sure yet. They haven't dealt with it yet. And they're also very concerned about reputational injury, that before they even get one of their first series out, they're already in trouble with whoever for bringing a claim. So that there is a sense, at least on the business level now, that the very newer buyers are actually stricter, despite the fact that most of them come from a very, very speech neutral world where it's just put up your own content. Now that they make content, they actually have become the most strict of some of the buyers we deal with. I don't know if you've seen like a differential between different types of buyers.
Yeah, I mean, I definitely think that, some of them get very comfortable, and it also depends on, honestly, who your counsel is. If they trust your counsel and they trust the opinions that we come to them with, and we're able to secure E&O insurance, which you guys can talk a little bit more to, they'll get more comfortable. One thing to keep in mind is when you, as the documentary filmmaker, are doing your deal with the buyer, at the end of the day, they're putting all of the liability and burden on you. So, they're the ones with the deep pockets. They're going to have to get involved in some respect, but at the end of the day, the full risk lies on the filmmaker. So it's a lot of liability to take on, and so really what we're doing day to day is trying to manage the risk. There's always going to be some risk of a claim, but I think, our goal is to reduce that risk as much as possible, and then, try to keep the conversation with the BA team at the networks or the buyers, keep them comfortable with what is happening on screen. And more, I think the truth is they need content that is going to be somewhat, shocking, and, that's what sells and that's what brings viewers. So they have to get comfortable with it to a certain extent if that's the kind of content they want on their platform.
What's interesting about it, though, is also in the last several years, there has been an uptick in frivolous claims that don't actually have merit, but they're actually being funded by right-wing groups. One of the biggest targets of this is John Oliver. His show has become a huge lightning rod for claims, despite the fact that the releases are very clear. There is actually almost no legal colorable claim, but they're being brought in weird districts, like places in South Carolina, places in the Midwest that have no real bench of First Amendment or IP lawyers or judges that are used to litigating these types of claims, so they're being kept in. Some of these claims are being brought on negligence, infliction of emotional distress, even though they might have signed a release, which makes it clear, could not be clearer that they don't have to know what the show is about, that they could even be tricked into knowing what the show is about. They could be mocked. And they're like, the very fact that you handed me that release, some people are bringing claims before they even sign to say that it was so hurtful to me that you would do that. And they've, in some cases, gotten through a summary judgment, and there's like actual things going on. So there is some of the insurance companies, despite the fact they know that the law is actually on their side, just feel as a means of managing their own financial risk and having to finance annoying things, are either unwilling to give you an insurance policy or expecting you to pay a lot more of a premium and a lot more of your deductible. So it's really important to figure out when you're applying for insurance, to think about which insurance brokers to go to, how to fill out your application so that you're not making risks seem worse than they are, knowing that you might have to have some backup plans and you don't want to truly get rejected before you try a new E&O company, because then you have to report that you were rejected by someone else, and all of this can be kind of tricky. So you need to really make sure that you have someone who's an expert in this helping you think about these issues before you even apply. I would also really recommend that many, many, many documentary filmmakers do not get insurance until the very end, because they're like, everything's going to be excluded anyway. Why would I get insurance? We highly recommend, not only do a lot of buyers require that even before you start, you get some policy, which at least shows that you're insurable conceptually, but there's a lot of things that can happen early in the development period today, which has been happening more and more. And at least if you have some development policy in place, you have a chance to try to get insurance. If you're a company, if you make more, several documentaries or several series, you have some ability in your yearly budget, you should have an overall policy so that at least you have something to turn to in the very beginning of your projects, because there's been a huge uptick in claims that come in the early development process, because oftentimes people are making movies about people who it's an antagonist, a true antagonist, where other people in that person's life, like maybe that subject is willing to be part of a documentary, but their followers, their handlers, the person who just had a falling out with them in some political drama no longer wants to be a participant. They can bring a claim early and you're screwed if you have nothing in place. So we're asking people more and more to start this process as early as possible. One of the things that actually just came up I think is important is when you have a story and you just remembering that you are responsible. At the end of the day, the buyer is going to say you're responsible, but what are you responsible for? As a journalist, you are actually responsible for the people who speak in your film. A lot of times filmmakers are like, but I didn't say that, so-and-so said it, when it's a defamation claim or a libel claim potentially. And we have to help our filmmakers understand that, no, you're responsible for the things that people say inside your film. So you have to figure out a way to tell, quote unquote, the other side of the story. But this becomes tricky when the other side of the story, you're either telling a verite story, and how do you get another side of the story woven in just from a cinematic point of view, but also when the other side of the story is not really true. It's kind of like alternate facts, but people are claiming those have validity and need to be actually part of a conversation, as we see that's happening sometimes in the news, where there's someone brought on to say the other side, but the other side is actually not true. And so how do we advise our clients when this becomes, how do we help them make sure they are doing their living up to their journalistic ethics so that they can defeat a claim of libel or something like that when the other side is bad?
So this is a really tough issue, and it's especially tough for folks who are trying to do pure verite, because if the show doesn't have an independent voice, if there's no voiceover or talking head interviews or nothing that can explicitly address the problematic portions of someone's libelous or defamatory statements, it can be very, very tough to put it in appropriate context. I think if you are dedicated to doing pure verite, trying to capture these potentially problematic statements in the right context can help. If there's any sort of government official, it used to be that they weren't saying things that are defamatory, but if government officials are speaking from their government office and in an official capacity, your right to report on the goings-on of government officials trumps other people's rights to bring defamation claims. You kind of scoot in under the protection that's afforded to public officials to make statements in their official capacity, and then our corollary right to report on them. So that's one option. If people are involved in a court case, that's another way to get in problematic statements while being protected. Statements made in the context of litigation, you can cover what's happening without, again, facing liability for basically distributing defamatory content. But beyond that, it can be very difficult. And so it can be that it's just not possible to do a verite, and you do need to add in voiceover or another interview.
Lower thirds.
Right, lower thirds. Something to basically put distance between the statements of this person, put them in context, show that they're an opinion, surround it with facts, but the truth is it's just very difficult, and I think we see all across the board the media is struggling with how do we cover without giving a platform to defamatory statements, and also without getting caught up in just republishing everything that's being said negatively.
Right. So one of the things that we're also seeing a lot of, we have many, many, many filmmakers who are making who are producing projects which involve the possibility of risk of revealing someone, the risk of they might be following undocumented people, and there's multiple ethical issues there in terms of potentially revealing where people are living, where people are staying, and or revealing sources in a journalist situation, whatever it might be, there are filmmakers are now at a place where they are extremely nervous, for obvious reasons, that their footage might be subpoenaed by people wanting to do harm, maybe to them, as journalists are now the enemy of the state. So they are now part of the story, which was really interesting in the Fourth Estate, seeing how much journalism itself is the story of the movie, and what it means to try to protect different things. So for example, there's creative things you can do. In that movie, there was a big fear that if you watch the footage, you could determine by seeing if there was a clock that was shown, or you could tell kind of the season and if there was a journalist on the phone with someone, the government could potentially figure out when that happened and subpoena the iPhone or the cell phone records and find out who that leak was. So figuring out how to protect sources is often a filmmaking creative decision. But it's also sometimes, what if you don't use the footage? What if you've done everything you can for what's in the diegetic space, but you have a ton of footage you didn't use. And your fear is it's going to be subpoenaed. And it might not be by the state. You might be covering a court case. It might be by the other side. It might be by some third party you never even thought of who, like, it turns out that person is in some future litigation you didn't even know about, in some civil thing, and it happens to track that, and some third party that you never would have thought to protect yourself against suddenly is trying to get access to your footage. But if you know your project is controversial, you know your footage might be a target, what are ways that you can try to protect that?
Sure. So there's a couple situations. The first is if, let's assume that you're covering a protest and there's police activity, and so you've got, like the Charleston riots. Let's say you're covering police activity, it's in public, there's a bunch of activists, and force is used. And so the police might informally approach you and say, we'd love to take a look at all of your footage. If you'd cooperate, this would be a great help to us. There, without a subpoena, you're freely available to refuse. And even if you, for project reasons or relationship reasons, are inclined to want to cooperate, we would always recommend that you say, look, we're happy to cooperate, but we need a subpoena so we can know what it is you want. It's a kind of good fences make good neighbors thing. Put on paper what you want. That way we can put on paper what we're willing to give you, and if there's any disputes, we can talk through it. It doesn't just have to be something over the phone and it'll be a he said, she said later.
What happens if that happens, like, while you're in the middle of a chaotic, potentially kind of, it's happening live in real time, and they take your actual camera, which might have footage on it?
So I guess if you're being arrested, we'll touch on that.
We can get to that.
But assuming that you're out of the way and you're not, basically being detained or arrested, the chances that the law enforcement will seize your camera, at least right now, I hope, are very low. Who knows where it will be in a year. But I think people might be hesitant to say, to refuse and say, no, go get a subpoena. But frankly, it's pretty standard. And especially if you're talking to somebody higher up, say, it's not just a random guy on the street, but it's either a detective or it's a prosecutor who's making the request for cooperation to say, we're happy to cooperate, but bring us back a subpoena. It's pretty easy to do. So then, now let's assume you're facing a subpoena. It depends if it's state or federal, because that will trigger now whether you have rights as a journalist to refuse to turn over information that might implicate a source or confidential information that you developed through the project. The state's shield laws vary wildly state to state. So New York, DC, LA, you're in a pretty good space in terms of your rights to resist a subpoena purely on the grounds of not wanting to turn over confidential source information. But if it's a federal subpoena, there is no federal shield law. You can make arguments and you can pound on the First Amendment, and I encourage everyone to do so, but there isn't a federal shield law that's recognized, and so there's a very limited ability to hold back.
What if it happens to you and you're doing a project? We have many people, again, doing things about refugee and immigration, the caravan, quote unquote. What happens if it's in a border state?
Yeah, so this is a great question. The federal government's ability to take draconian action near the border is kind of at its height. There's the famous 100-mile wide Constitution-free zone. I think that's a little bit of a exaggeration, but the truth is that if you were filming something at the border, the government's ability to detain you, seize property in the name of national security to prevent, to preserve the integrity of the border is very high. So,
can they reach that even later because it was filmed at the border?
It's unclear. So the seizure ability, I think, is directly related to being at the border in the moment. So if it's 3 months later and you have footage that was relevant to that, they'd likely have to go through the same subpoena process. But so one pragmatic thing you can do, if you know that you're likely to capture footage that is going to be controversial or you don't want to have to deal with the subpoena issue later, you don't have an obligation to preserve and hand over evidence before you know about the police's interest in it, whether by a request or a subpoena. So if you have a policy, you say, I delete, every second week I delete all the footage that I haven't used that I don't think I'm going to use, or I don't keep my dailies past, a few days, or at the end of the project we delete everything. As long as you have a policy, we encourage you to write it out, to agree on something, and then everyone live by it. Because if you delete your footage or your notes according to some policy, it's very difficult to say, well, you deleted it on purpose to thwart the government's ability to get their hands on evidence that might be related
It's
to the
obviously
case.
very hard from a creative point of view when you actually
Right.
are not ready to even make those choices for a long time until you see where your story is leading. This is sometimes easier, I think, for series producers who have sometimes, not always, a more specific through line and idea of each episode, and kind of they know what they're getting. Everyone wants to have as much coverage and as many choices in order to cut together something later. But you have to really think this through. But the problem is, it can't really be on a project-by-project basis. You need to make sure that this is a policy you have as a filmmaker. So you have to kind of think about who you are as a filmmaker. Is this something where this movie is going to actually be a huge exception to your rule, and like you're going to try to lay as low as possible and deal with it? Or are you in the business of this so that you need a policy that might force you to make creative choices earlier than you would like?
Yeah.
It's a Hobbesian choice. We're not saying, when we tell this to filmmakers, they don't like us.
It can help to know when the likely points at which the government will become aware of the footage would be. So it's a little bit tough. If you are at an event that gets a tremendous amount of coverage, then it's kind of out that you might have footage. But if you're doing, say you're embedded pursuant to an access agreement that Julie described, the government might only realize the scope of the footage you have later at the review point that it's been negotiated, and that might be towards the end of the project. So if you know that that's the deal you're going to sign with law enforcement, you can put in place a policy where we're going to delete the unedited footage prior to the review. And as long as there's no subpoena in front of you, or you haven't been notified by the police or the law enforcement that they want footage, it's your property. You can delete it as you will.
And just one thing to add to that, it also depends on how your project is being financed. If you have a project that is full work for hire project for a network, maybe you have a deal with Netflix or HBO and they own it outright, you have to make sure that you talk to them about this, because at the end of the day, they actually own all the footage. So you need to make sure that they're fully on board with your process and your procedure, and that they understand why you're doing it, because it technically is owned by them.
I mean, most of those buyers at an HBO or Netflix are usually extremely used to this. They do so much of a volume business in these types of projects that none of this will be weird to them or different to them in any way. It becomes more complicated when either old buyers are trying to do new, interesting things, except thank God many of them have done the cop shows, which has been actually helpful for us. Or there's just brand new buyers who don't have a policy about that, and they have to think it through on their feet, and not always, their BA doesn't always come from this background. So it's really, it can be somewhat tricky. I mean, would you say, like, in the course of your practice, you do a lot of true crime projects?
Yes.
So outside of the scope of the political situation we're in, just in a situation where there's projects where people are accused of something and it hasn't been fully adjudicated, they have a defense lawyer who might want to see your footage. They have all different, or there might be victims or alleged victims who might want to bring civil actions for restitution or other types of litigation oriented where they need the footage. So do you tend to see that people have a policy in place? How are most of your clients dealing with it?
Yeah, I think for the most part, we work hand in hand with the networks, and this is with Oxygen, this is with Discovery ID, and we put a policy in place. And sometimes it's not super relevant, especially if it is an adjudicated case, but if it's not yet adjudicated, I think they are used to working hand in hand on a policy so that we are able to delete raw footage. And I know Andrew has dealt with this a lot too, as far as working on that policy and putting it into place with the networks and our clients.
And keep in mind, it becomes even trickier if you're a filmmaker who uses animation or reenactments, so that you're not actually using actual footage of events. You are doing things that are both supposed to be a documentary, so you have a certain level of rights, but you're also scripting things that may or may not have been the exact things people said. And so all of these issues become even more complicated if the filmmaking strategies you use, just from a, authorial and creative point of view can also make some of these things even more complicated. So it's important to really think through, and when you're talking to your counsel about how to imagine doing these things, it's important that you tell them from the beginning, by the way, this is going to be hybrid. There's going to be a lot of reenactments. There's going to be animation. There's going to be audio with this unclear who said what. And it's real found audio, but it's impossible to really know who's saying what. And therefore, there's a potential of many people thinking it's them or being accused of it being them. Those kinds of things you should be talking about at the earliest stage that you know it. You might not know, right? You don't know how your project's going to look, maybe even what it is, really. But as soon as you do that, we encourage you, not because we're here to try to stop you from being creative, we're here to help you be as creative as possible and think about the risks early so that you can do what you can to achieve your vision as risk-free as possible. So speaking of like the ultimate risk, I think, and this is something we really feel is, I can't believe we're talking about this, but I'm someone who is an active protester. I don't, for a lot of reasons, probably because I'm scared, I choose not to get arrested when I do civil disobedient actions. I've done it a lot over the last year. I've done it 6 times. Every time I do it, though, I'm the legal observer. You don't have to be a lawyer to do it. I encourage everyone to do it if you care about these issues at all. And my job is usually to hold the medicine, if someone needs medicine, their ID if they need it, in different ways, and stay as close as I can to the people being arrested. The other thing my job is to do is to record it, Facebook Live it, whatever. In the early days, over the last year, the Capitol Police were probably much less exhausted also as part of it, just on a personal level. And it was very clear that they let you walk with the people that were being arrested and film them. It was no problem. In the recent time, in the Kavanaugh protests, there was a complete crackdown on even shooting it. And this is just as your regular First Amendment, you know, you and me with our iPhone, being told that we were incommoding, we were stopping the people from walking when there was literally nobody in the hallways of the Senate other than the protesters, and they would put their hand up in front of your iPhone. You can scream as loud as you want that you're violating my First Amendment rights. I'm a lawyer. I know that you're doing that. What is your name? And at that moment, it really doesn't matter. And if someone's about to put your hands behind you with plastic cuffs and take your footage, you need to really think both as a citizen documentary person and as the filmmaker, if you're really doing this kind of professionally, what do you do in that moment to protect yourself, to protect your story?
So here's an opportune moment to draw the line between your legal rights and the reality of, there's an angry police officer in your face. And so what Victoria has explained is that you need to go in there with a plan. You should choose to either be the documentarian who's slightly removed from what's going on, filming either for security and evidentiary purposes down the road, or to document it and truly spread the word. And it's difficult to do that while also being the activist who's being the, primary disobedient person. So being thoughtful with how you're covering things, having a plan is very important. And to know that in the moment, shouting that you can't do this, this is the First Amendment, is unlikely to result in positive outcomes for you. So having a strategy that as soon as there's a confrontation with law enforcement, instead of loudly demanding on your First Amendment rights, understand that you might be detained, there might be an arrest, they might take your property, but developing facts in that moment and kind of thinking a little bit lawyerly. So if a police officer is got you on, I like the DC, was it incommoding? So in New York, it's discon. It's if there's 2 or more people blocking the streets or vehicle pathways, regardless if there's any people or vehicles trying to get through there, you can be detained for disorderly conduct. I mean, pretty much every jurisdiction has a variation of that. So in the moment, it's not, you can be detained or arrested. So just shouting First Amendment and hoping they'll go away is unlikely.
It actually seemed to work the opposite.
Right. So
Just for the record.
As a practical matter, a lot of police training is, regardless of the situation, if there's somebody who's defying your authority, you have to establish dominance, secure the situation, and deal with the legalities of it later. So by keeping your cool as much as possible, If somebody seizes your phone, instead of trying to seize it back, now you're touching a police officer, you're resisting arrest. The more you do to exacerbate the situation, and it's an unequal power dynamic, and it's not in a better situation, it wouldn't work this way, but we are in the reality we're in. You have to keep your cool and cooperate, ask questions. So instead of saying, you can't take my camera, officer, I understand you've taken my camera. I would like a property voucher. Where can I get a property voucher? Where can I get my camera back? Who will be holding it? Where are you taking me? Questions that ask for information can be helpful. The calmer you stay and the more space you give them, it provides less opportunity for pretextual detention. So, if you touch the police officer, that's generally enough to arrest you. So just being aware of where the line is and knowing that you're not going to vindicate your rights in that moment. You're going to vindicate your rights 4 hours later when the desk sergeant has to hand you back all your property because it was a BS arrest. And you get to
4
there.
hours, you'd be lucky.
Right. You get to there by being calm in the moment. Other things you can do if there's any ability to shoot footage or photography that can be dynamically uploaded to the cloud. One thing people worry about is, will the police delete my footage? Will they look through the photos that I brought with me that are already on my camera? A way to protect against deletions, obviously, if you have the technological means, things can be saved to the cloud automatically. That cuts down. But even just knowing a simple photo count, I rolled up today, I had 30 shots on my camera, I took another 50 during the protest, there should be 80 on there, and if you get your camera back 6 hours later and there's 75, well, 5 are missing. So just being aware of where you started and what the state of your property is when you get it back can help.
Also, you should disable your touch screen, your thumb thing, because without an actual warrant, they're really not supposed to be able to force you to open your phone.
Right.
But they can sometimes actually, and this has been done, they kind of force your thumb on it. So you should, if your goal is to document a protest in any of those, I highly recommend, at least for the day, disabling your thumb.
Yeah, that's a great point. If you cannot be compelled to give over a password, because that would be your right to remain silent if you are arrested or detained. You don't have to tell them what your password is. But the rules on biometrics, face scans, your thumbprint, if your phone opens on your face and the cop just holds the phone up to your face and your phone opens, well, that's too bad for you.
Yeah.
That's not considered a search. But
just turn that off
right.
before you go out that day. So I think we have, we're supposed to be leaning towards questions. So do you want to?
Perfect timing. So we got 10 minutes for questions.
So we have 10 minutes for questions.
I have a couple of questions. What about if you're filming in a space that's not public, but you put a sign or release outside that says anybody that enters into the space gives permission to be filmed? Does that hold any legal weight?
Do you want to answer?
So it depends on the space. If it were let's say it's this event, we'll call it mostly public because pretty much anybody could purchase a ticket and show up here. If you had the consent of the organizers of the event, who ultimately control whether or not you can film in that space, then yeah, it is pretty good. This is a mostly public gathering. You have probably a very limited expectation of privacy here. And you don't have to come here if you don't want. So if being filmed is a condition of coming to this talk as decided by the organizers of the event, certainly it holds legal weight. Where you run into trouble is, we've had clients who want to post those signs outside of Sunday services at a church. I think a judge would be hard-pressed to say a person should choose between whether they can go to worship on Sunday or be filmed. Hospitals, doctors, offices, places where people have a kind of urgent need to go or a long-established right to be and be free of kind of being watched by or recorded by other people. But I think it's the exception rather than the rule. If you put up a couple signs around Union Square and start filming, combined with the fact that people's rights of privacy in public are very low, it is effective. It's certainly, when it comes to primary focuses of your documentary, so if people you're interviewing, people who have substantive speaking portions. We'd prefer they be released on top of it, but it is effective for kind of background B-roll shots in public. That's not the case in a lot of other countries, like Japan. That won't work.
If you do have a location release, and they've given you permission to shoot there, and you put it outside,
It's still the issue that we talked about.
It's better than nothing. It's better than not doing any of that. But if someone really said, I refuse to be part of your program, this is my church, every 10 o'clock mass I'm here, and they go all the way to sue and say, I didn't want to be recorded and I ought not to have been recorded there. Pragmatically, I just think a court would say people are allowed to go to their house of worship without being recorded if they don't want to be. And it's not the same, even though it is a public place. It's not the same as a park or a courthouse or a school.
Or a Cineplex.
Yeah.
And just to clarify the difference between a location release and an appearance release, the location release really is just granting you access to film in a place.
And possibly use
right?
their trademarks.
So there's and possibly use their trademarks. So it's really saying, okay, we're not going to claim trespass that you came here with cameras and filmed on our property. The individuals who are being filmed within that property have their own separate set of rights. And so that's what you're looking to obtain when you post those cable cast signs or when you have them sign an appearance release. If you're if you focus on any individual, we always recommend that you get an appearance release signed.
To the extent possible.
Right.
but in medical, you said that if you're shooting in a medical situation, I worked on a show called Paramedics, and I remember there was a law that was changed, and that you actually had to get personal release.
That's a separate issue. First of all, he's saying that in a medical situation, it's the same like a church, that you shouldn't rely just on the sign because it's a place where people have no choice but to go. So you can't say like you didn't have to go in. Of course you had to go in. You had an urgent care visit. But then there's also HIPAA issues, which has to do with releasing medical information. So it's a whole other stuff.
Some people were coming in hospitals in the case of emergencies, and you were able to film them and get the release afterwards. But then there was a law that was passed that made it illegal for you actually to film them without a release.
Right, that's probably based on HIPAA issues. That has to do with private. You're not even allowed to record certain kinds of private information without a pre-release. It can't be done post facto.
I see.
Yeah, sort of a deep question. Can I ask it? GDPR, are you seeing, Andrew, it said that some attorneys out there are taking the view that a photo once image really public face equals personal data. Are you seeing any other, I had a question where someone was asking, is just the face without any biometric analysis on top of it, personal data, and obviously that would have huge implications for filmmakers, although I understand that, there's country-specific exemptions now for artistic expression that are in the process. So I just wondered what you guys are seeing in your practice in terms of GDPR coming up and how it's coming up.
So the question was about whether, have we seen the GDPR popping up more in other contexts in our documentary work? GDPR, if you move any rock or anything, like it just jumps out from underneath there. I think the big date was May 25th of this past year was when it went into effect. And I think a lot of people were looking at that as like the end of a process. So now the law is here and we'll all understand what it means. But the truth is that nobody has any clue. There hasn't really been much enforcement. Anything official that's been said about it has been very vague. And so the truth is we're not sure if filming somebody stating their political opinions in a quasi-private environment constitutes personal information. I think from the American perspective, it's really hard to wrap your head around that. But the truth is that the First Amendment is pretty unique across the world in terms of the scope and protection it affords to expression and the right to record other people.
And the cultural norms
Right,
that it
and the-
creates in people's, even the way they think about things.
So we are seeing a lot of uncertainty, and unfortunately, we don't have a lot of good answers. I personally would encourage documentarians to keep pushing and try to preserve as much as possible our free expression culture, even when you're abroad, but it's challenging. And it means what we have seen is a kind of skyrocket in the amount of local counsel advice that we need to seek so we can understand the issues and advise intelligently.
It's a boon for international lawyers.
Yeah, yeah. If you're a privacy lawyer in Europe, it's a good thing.
You're suddenly very, very busy.
Yeah.
Hi. I was the subject of a 60-minute story a few years back regarding international custody of kids. I consented to the interview and that was fine. However, during one of the family court appearances, a celebrity had an appearance that same day, recognized me, came up and started an argument with me. There were cameras there that taped the whole thing, and as I'm leaving, A&E is running up to me saying, sign this release, and I said, do I get paid for it? He goes, no, we don't pay. And I said, no, I'm not signing it. They actually aired the footage a couple months later, and what they did was they blurred out my face and they altered my voice, so the argument is there, but, you know, there's no way to show that it was me. When that happens, does a person have a claim? You know, does a person say, look, you used my voice and what I said and what we argued about, you did it without my permission.
Right, but you don't own your voice or what you say,
Yeah.
right? That's something you let out to in the world, so you don't own it. What you owned is your right of privacy and your right of publicity, potentially. They might have been able to show it without even blurring you, and you might not have had a claim. You did that publicly in a courtroom, but they probably did it because they didn't want a claim from
Right.
you. But no, that's part of what we do, that we live in the world, we interact with one another. We don't own our speech, we own our writing, right? We own things when it comes to copyright. If we have a unique and original thing that we fix in a tangible medium, that is now something that you can own, and there's a lot of indicia of ownership and control that you have because of that ownership. But our expression in life in an interactive world, especially in a public place like a courtroom, is not ownable in that way.
Right.
I lost my right to publicity when they blurred me, is that?
Well, your right of publicity
You were
controls.
protected from the tort of the right of
Yeah,
publicity.
your right of publicity controls commercial use, and so if this show is anything creative, you know, even unscripted or reality TV, it would be considered not a commercial use, even though people are making money on it, people are being paid for it. If they had used that segment for shampoo commercial, then you've got a claim because you didn't consent to the commercial use, and commercial meaning literally offering for sale goods and services.
But the blurring might change the.
Right. So the blurring, if
And
you're
the changing the voice.
Right. I'm sorry. I should have said that. If they hadn't blurred your face or changed your voice in the moment, you might have some rights. And then the only other thing I could see is if it sounds like this conversation was on some sort of topic of public interest, but if it was purely private, let's say he owed you money or vice versa, right? It had nothing to do with anything newsworthy, and it was just kind of a private discussion or debate that was caught on camera, you might have something, but it's very, very
Depends on
narrow.
the state.
Depends on the state. You're in a courthouse, which is kind of a bad fact because that is a very, very public place. It's one of the, besides public parks and a courthouse, there's very few places that are at the center of the First Amendment right to kind of record what's going on. So it just is a bad combination of facts, but no, you really wouldn't
Sorry
have
it
a claim there.
happened.
Yeah.
I wanted to just, I noticed that you asked if you could get paid for that appearance,
They
and
kept running up to me saying, would you sign this release? And I said, well, what does it pay? They said, no, we don't pay. And I said, no, I'm not going to sign it.
yeah, so actually I think it's important to note that when you're producing a documentary, the policy, across the board with all of the platforms that we deal with is that you don't pay for interviews. You don't pay for documentary participants because they feel like in some ways it could impact the integrity of what's being said. Almost rising to the level of a performance, being paid to give a certain viewpoint as opposed to, sharing.
That being said, if it's a major subject of a documentary, there is an expectation that you potentially would pay for exclusivity, you would pay a stipend for time, you might pay money that's attributed to the use of materials, like a license fee for all the photos they're going to share with you, the promotional stuff they'll do for you, because there's also, historically the bias in the way we thought about these things was why should you, it could corrupt the truth of something. But there's also a flip side that you make a ton of money off of someone's life and they get nothing from it. so there is a tension in that when it comes especially to a major subject. And a lot of the buyers are actually very comfortable with a form of payment that isn't payment to appear.
Right. Yeah. I mean, we'll see it sometimes as like a consulting agreement. You know, you have someone who's doing research for you. They're an expert in their field. Maybe we don't want to structure that agreement with them as we're paying you an appearance fee, but we'll structure it as we're paying you a consulting fee or a research fee.
For the life story, if you're filming somebody and you think that their situation could be ultimately sold as a feature film or something.
That would be a different part of what you're paying for, and you can negotiate that, and it's usually depending on the leverage of the subject, they might not agree to pre-negotiate what that is, but you could try to get an option on it or some kind of shopping arrangement where they can't do it without you. I highly recommend doing that, actually, if you believe that there's remake fiction rights, because from a pure legal point of view, the new producer may have no use for your documentary whatsoever, because once you made it, it's facts, unless your documentary has become such a good title or something someone really feels like they need it, or because Hollywood loves to have fake IP, and lots of reasons why they do that. They could just try to come and get the rights to the people in your movie, and you're shit out of luck. So it is sometimes a good idea to see if you can get some form in your access agreement or your release that has a portion of it where you have some ongoing relationship to the fiction rights that would come out of the person's life story. But that's often a very complicated negotiation that may delay you getting the access to the person. That's a strategic decision that you have to make based on the facts, in front of you on every project.
And just one extra thing is, if the person you're considering paying is a convicted felon, there's a whole bunch of rules about whether or not you can pay for the story. The
Son of Sam.
Yes, they stem out of the Son of Sam ruling. The idea that convicted killers shouldn't be able to profit off of the facts of the murder. A lot of those got struck down on First Amendment grounds because they put the onus on the documentary filmmaker to not pay somebody for their story, which is obviously very problematic. They've almost all been reformatted to be that a felon can't accept money, or they have to disclose it, or they have to give notice. They vary state to state. It's a lot better now, so it's less of a risk, but it's still, if you are considering giving money for an appearance or for information or materials to somebody who has been convicted relating to the reason they were convicted, it's just helpful to know what the rules are there in terms of payments.
It could be a reality TV series that you think that they could be appropriate for. So you want to get those rights up front so the network doesn't come in and steal it from you.
Right, you just
Right,
have to,
most likely, though, the network who's paying for it is going to own the copyright to what you do, and they're going to have the derivative rights to begin with. So if they're paying 100% of your series, it would be a very unusual deal in your production services agreement with that buyer that you reserve the fiction rights unless there's a huge bidding war for what you're doing.
Well, you lose a lot of leverage if you don't control the rights to that particular person. And
You'll lose a little bit of leverage. In general, if someone's paying 100%, they're going to like it better if you have those rights because they're going to want them, so you have something more to sell to them. But I wouldn't think, as a rule, you're going to be able to reserve it for yourself. It just helps your project maybe be worth more to a potential buyer.
Right.
The damages be in a right of publicity or privacy case, like in that gentleman's example, is it negligible, like a few $100, maybe $25? I'm just thinking of, like, if you had a documentary, you wanted to put someone on camera, and you were kind of balancing the risk of, all right, well, I didn't get a release, but I'd really like to have this guy talk for 15, 20 seconds.
right, so the right of publicity, again, it has to be raw commercial, so.
Your
so-
documentary isn't going to trigger that issue.
But quickly, the scope of damages there is the profits earned off the back of the person's name, face, likeness, et cetera. So it could be sizable, but it almost never comes into play for a First Amendment protected work like a documentary or a news report. Right of privacy, Hulk Hogan got $150 million. So it's whatever 12 people in a box think the damage that was done to somebody's reputation.
I mean, that's what we're living in, a world in which there are high net worth individuals and forces
Right.
that are willing to fund litigations to try to squelch speech. So
The more cogent question, though, is not what could the end of the day liability be, but what would it cost if somebody sued me because they don't want to be involved in my documentary? You're going to have to pay easily $20,000, $30,000, $40,000 just to deal with it if it is a litigation. And that's the issue that a lot of filmmakers are dealing with. And to go back to Victoria's point about the importance of E&O, you know, having a backstop there. So even if you are 100% right on the law, and at the earliest possible moment you get the claim dismissed, it's still the better part of $50,000 or $100,000 to get there.
And you have a deductible.
Right.
Even if the E&O is paying for it, you have a deductible, and your network is like, that's on you. Our indemnities
Right.
completely work such that you are responsible for anything over the claim and the deductible. Now, some buyers are extremely nice about it, and you're a repeat player with them. They're not. They might split it with you. They might even take it on. They don't want to put you in that position. But I wouldn't hold my breath.
Right. The other thing to keep in mind is when you're delivering your final product to the buyer, you're going to want to include within those deliverables a chart of restrictions on use. And one thing you should always note is please don't use these people in ads and promos, because that helps prevent a right of publicity claim.
Even though those promos under pretty great case law is still considered not to be actually commercial, it just also raises the risk level.
Right.
If someone keeps seeing themselves in a commercial, it's very different. They get more annoyed. More potential people see them for what they're worried or seeing them than if someone caught them in a weird moment watching the full documentary. So one of the things that we encourage is it's not really about right of publicity. It's about if you feel nervous about a set of footage, why put it in your trailer? Why, you know, like if you're going to do that because it's really important, everyone needs to really be prepared. Okay, we're taking a big risk together. And most of the time, your buyer is not going to want to do that, even though they love that footage and they think it's like, it's the trailer, it's the money shot in the trailer. Be like, okay, if you want to do that, buyer, I've warned you about that. In this case, I need an amendment to our production services agreement, which makes it clear that you're actually indemnifying me for this, because this is something I am worried about, and I do not feel like should be in the publicity. And sometimes I will agree, and sometimes I'll say, you repped and warranted, everything could be used. Sorry.
Right. It's useful to think about risk as a resource, a limited resource like anything else, like time, like money. So it's thinking about, okay, those 20 seconds, that's compelling footage, but do we want to spend the amount of risk tolerance we have on this, or is there something else that's more essential? Is there a different way we could portray this or put it in context to reduce the risk and reduce the amount that you have to kind of spend on a particular shot?
I think we need to wrap up.
Okay, we're wrapping.
Thank you very much,
Bye,
everyone.
everyone. Stay
Thank you.
safe.
Yeah.